Good afternoon, everyone, and welcome to this webinar on IP protection in health software. This is the second webinar of the JoinHealth Autumn series. And for those who are joining us for the first time today, know that these webinars are a joint initiative of the Health Cluster Portugal and the EIT Health, herein represented by Miguel Amador. Today, to present this topic, we have Robert Harrison from Sonnenberg Harrison to present the landscape of software and AI patents, followed by Daniel Vasconcelos from Inesctec with a presentation about management of software patents on a TTO. I would like to thank you both for being here today. And to let you know to all of the participants that at the end of both presentations, we'll have a few minutes for questions from the audience. So feel free to use the Q&A tool and ask your questions to these two speakers. Just before I hand over to Miguel, who will introduce the speakers, just to let you know that, as usual, the presentation slides and the recording of the session will be available after the webinar. To receive the presentations in your email, please provide the email address on the survey after the webinar. And regarding the recordings of the session, they will be available at the Health Cluster Portugal's YouTube channel. So now to present the speakers of today's session, I'll ask Miguel to take it from here.
Thank you, Patricia. So we'll start with Robert, as is one of the experts on this software, and now probably going into the AI field. So I think it's quietly engaged today. If an AI system can patent something, so it's good the challenge. But just to quickly introduce, so Robert is a European patent attorney. He worked as a patent engineer in IBM in the past, so he quickly moved from only semiconductors and electrical stuff to actually what you can do on those systems. So I've been working for a while also with software and AI systems, and will give us a little bit of introduction and present a case study on how can you actually patent something that includes software. So Robert, thank you, and up to you. So if you can unmute and put your presentation. And also unmute, still muted.
Unmute me. So
yeah.
Thank you very much indeed, Miguel, for that introduction here. And it's a pleasure to be here with you today to talk a little bit about software, artificial intelligence, and patents. And first of all,
can you just share a presentation? I'm not sure.
Yes, I'm just about to do that.
Okay.
I'm just about to bring up my presentation here. So I hope that participants can now see your application. So I hope that everybody can see it here. And what I want to talk to a little bit about today is to get rid of the myth that you cannot patent anything we're using software. And I know some of you had the pleasure of listening to the examiners from the Portuguese National Property Institute last week, talking about how patents are granted, what the requirements are for patents, and also the fact that you can't get patents for certain things. However, what I am going to show you today is the myth that patents cannot be granted for software for artificial intelligence is really a myth, and that we are increasingly seeing a large number of patents in this field. That's just a little bit about the firm. Miguel's been quite kind to actually introduce me. One thing Miguel didn't mention is I actually spent a couple of years working as a patent examiner at the European Patent Office, which was an extremely valuable experience, actually understanding how the Patent Office actually works in practice and how the examiners look there. These days, I'm working as a patent attorney. I actually live just outside of Munich, so you can see the beautiful background. It's unfortunately not the outside of my window, but it's about 50 kilometers from where I live, but working with a lot of companies throughout Europe and lots of institutions as well. So what we're going to be talking about today is, let us suppose that you've got a digital health application, and you want to protect this digital health application using industrial property. What we do know is, firstly, your software, your computer code is protected by copyright. which is within the whole of the world. You don't have to register copyright in Europe. Some people ask, can you register it? You can do it in the United States if you want to. You can do it in China if you want to. But within Europe, there's no need to do it. As long as you've got a good software development system, which records when code was developed and by whom it was developed, that's all you actually ever need to do. If your code is ever copied illegally by someone, then you're actually able to go to court. Code software can often be protected by trade secrets, particularly if you're just selling your products with object code without even providing the source code to it. Now, that's a decision that you have to make, whether you want to do it or not. And I know Daniel later on is going to be talking a little bit about that, whether it's how to use open source software. But when I worked within IBM, a lot of what we were doing, we were not actually releasing the code freely into the environment. We were just keeping it very confidential with some of the tricks within our ecosystem. And finally, and this is the main focus of today's presentation, software implemented inventions can be protected by patents. Now, I know, and you can probably read, computer programs as such are not protectable by patents in Europe. That's true. The same is true in Portugal, by the way. The same is true in the UK. The same is true in Germany. You cannot protect computer programs. But what the courts have actually said, what the patent officers have said was, well, that's almost crazy. Why can you protect an electronic circuit with a patent by putting together all of these transistors, capacitors, resistors? But the same sort of thing you cannot protect by using software. And the classic case that this was decided upon was about 20 years ago. And it was all about signal processing. And those of you who are into or understand about signal processing of signals in devices and diagnostic devices, you will know how important it is to remove harmonics. You will know how important it is to remove the noise from the signal, to extract that information. And how did we do it? Well, when I was growing up at my high school, we created circuits, RC circuits, electronic circuits to remove a lot of this noise. Computers were just starting in their development. When I went to university, we were doing the first computer programs that took in the digital data and processed the data. And these days, it's almost done automatically. And the patent office said, well, if the same thing can be done with an RC circuit, an electronic circuit, it could be done with software, why shouldn't you be able to patent software? And of course, that then led to the decision that as long as you have a technical implementation and a technical application of a computer program, then it can be subject to patent protection. So you can't, for example, have fintech patent applications, at least not in Europe. You can in some countries, but we're going to focus very much upon medical applications, digital health. We're not going to be talking about financial or business methods. If anyone's interested, we can talk about that separately. But our focus today is going to be very much on digital health. The other important intellectual property that you will have developed within the digital health ecosystem, of course, is your data. It's all about ownership. How do you actually own the data? How do you process the data? And a lot of that is going to be tied very much into the algorithms that you'll use for processing your data. Now, there are ways and means of protecting data in Europe. Collections of data are protected by copyright. There's something we call the database protection. So in Europe, it doesn't exist in other countries, and that can be really valuable to you. In fact, one of the biggest court cases on data protection was created by MIMS. Well, some of you may know it. It's a pharmaceutical handbook, which talks about all of the adverse reactions and the like. And that was a massive win for the company that's collated all of that data, put it into digital form, selling it as a database, and they were able to make a very, very good living out of it. But our talk today is going to focus on this central issue of patents. Where do we go from patents? And just to give you an example, this is not just limited to artificial and software, medical informatics and the like. This is everything to do with artificial intelligence. The World Intellectual Property Organization is a UN-based body in Geneva which collects data all about patents. If anyone's filed what we call a PCT or an international patent application, that you will know about WIPO because they're the people that process that patent application. But one of the other jobs that they do is they collect statistics. And in 2019, they collected this statistic and which showed how many patents were being filed, not yet granted, filed in Europe. Sorry, not just in Europe, worldwide. And you can see that in 2017, it had gone out to about 60,000 patent applications that had actually been filed. That data has definitely increased. There's no more modern statistics that I know about, but we're probably approaching somewhere about 100,000 patent applications a year. I see it all the time when I'm preparing and working on patents, just how much is coming out of China, for example. Some in English, most of it just kept in Chinese, but also in the United States, and Europe is slowly catching up to in that. So we are seeing a lot. That doesn't mean all of these are being granted. There's some restrictions about granting patents, some of which I'll come to later on. But what I want to take you through is a study that came out of Porto's Inestek Institute a couple of years ago. And this was all about, essentially about identifying tissue for breast reconstruction. Now, I don't know, I guess most of us, probably many of us, will know somebody who's had breast cancer. Either friends of mine, I've had several friends who've got breast cancer, I've had a couple of relatives who've had breast cancer. And you will know that one of the issues is after the breast has been removed, it has to be reconstructed or needs to be reconstructed. And obviously, traditionally, you've been able to use silicones or plastics to do that. But wouldn't it be so much better if you could use certain types of tissue to do that? And where do you take that tissue from? Well, basically from the thigh or from your leg area. And the point about it is you can only take certain types of tissue that come out of it. And how do you actually identify what type of tissues come out of it? Danny will be able to give you a little bit more of the background here because Danny was also involved in this case. But basically the aim of the invention that we had here was to take the existing X-rays to identify suitable tissues and particularly the way they were, the blood vessels went into them, and to use this material in order to be able to select the right material for breast reconstruction. So the patent was actually filed back in 2018. You can see this is the European patent application, and there's the date of it, there. And if you can look it up, just find that patent and you can actually understand how the invention works. But that's not what I actually wanted to talk to you about today. I wanted to talk to you about how we actually filed that as a patent. And basically, we took photos from a hospital. I'm not certain I can reveal the name of the hospital. Daniel will tell you if I'm allowed to reveal it. But basically, they came from some really experienced surgeons, I think in the Lisbon area. And they had a large number of X-rays. And they were actually able to identify the suitable type of blood vessels that could be used for this breast reconstruction. And Inestek got a large number of these X-rays, which had been labeled by experts and processed them into an artificial intelligence system. And then what they did is they were able to use that neural network in order to identify in future automatically from X-rays the type of suitable tissues. So you don't need to have every time an expert studying it. So let's just think about how we actually prepare that application. And let's also think a little bit, if you are interested in something like this, how you would go around briefing the patent attorney to draft a really good patent. That patent, by the way, that I just showed you there, the European patent application, we also filed that in a number of other countries. So it wasn't just designed for Europe, it was obviously designed for other countries as well. So we took the original collection of data and photographs, all of which had been labeled by skilled specialists who'd said, this is the type of tissue we need, these are the type of blood vessels that we need to think about, this is where the segmentation comes in. I'm not going to worry you too much about the technical terms here, just take it, we're looking for a particular type of blood tissue. We annotated these photos. The most important thing, you have to use good data in order to be able to get a good invention. You've probably, when I worked for IBM, we used to talk about garbage in, garbage out. You don't have good data, you don't have good labeling, you will not be able to get a good invention coming out, a reliable system coming out. And then what we had to do, we had to train the neural network. Now, it wasn't that we were using an absolutely novel neural network here. I'm not certain where they got this neural network from, I can't remember. But the ones that are available in MATLAB or some of the other libraries around the place, that's all we need. Yes, I know they are known, they are prior art. We need to tell the patent office what we're doing, what data we're inputting in there. And if anyone looks at those patents, I've got a couple of figures later on, you will see that we've explained to the patent office in some detail what type of data, how we labeled it, what we were looking for. So we train our pre-existing neural networks. So the networks existing, we're using basically off-the-shelf software to do that. But what we were able to explain to the patent office is that for the first time, we have got data, we've got photographs, we're actually able to train this neural network for a new application which nobody had ever done before. Well, it turns out that a few people have done something similar, but not in the same way as was being done from Porto. So once we did that, we filed the patent application, and there was that originally filed back in 2017 in Portugal, and then later as a European patent application here. We wrote the patent application. We explained in some detail, it goes on for about 10 pages, I think, that patent application, what data we were inputting it, how we had been inputting it, how we'd actually labeled the data, and explained some of the results that we were actually getting out. So the patent office came along, looked at it, the patent examiners, and I said I spent the first couple of years of my career working as a patent examiner. They have some really good tools to actually understand, to find out how new and novel that patent was. And the interesting thing was they found no patents whatsoever. Nobody at all in the world had thought about using this artificial intelligence system for a similar idea. What they did find, it has to be said, was a couple of academic papers that have been published on a similar system. And I emphasize a similar system. The system was not identical. We talked to the inventors. In fact, I was down in Porto talking to the inventors one day, and the inventors were able to say, yes, we knew that piece of work, but what we did was something slightly different. And because of this slight difference, we actually went back to the patent office, explained in some detail how we had actually made it different compared to what other people have been doing. And it was basically a slightly different way of processing the data. The photos might have been the same or very similar, but we'd explain that anyway, but it was a different way of doing it. And then later on, the patent office actually approved that patent. What we were able to do is we were able to show the patent office that we had a technical implementation. We were able to show that we had an application to medical devices or medical fields, and therefore it was not excluded from patent protection under the rules that exist in Europe and indeed in many countries throughout the world. So what happened at that? This is what they actually decided to grant us. So this is basically some of the labeled diagrams. This is just taken from the patent application that I filed. And the patent office at the end of the day basically said, okay, what you are doing is this method, which I've summarized very quickly here. You were able to automatically take the data, the photographs. You were actually able to process the data. You were able to use this method that I've set out here in order to identify those images, which are going to be really interesting for you to process. And then you're actually going to be able to work out where the tissue is that can be used for breast reconstruction. So what we had here at the end of the day was a method for the segmentation of blood vessels. And I think I said at the beginning, part of the crucial thing about breast reconstruction is whether you can actually get a decent blood material with the right type of blood vessels in there. So we acquired a plurality of images with the plurality of voxels. For some of you who know the technical term, it's like a pixel, but it's actually a volume. Define what's called a facial layer between a muscular region and a subcutaneous region. And therefore we did that by looking at the different types of images. As I say, these had been original, the training set had been labeled so that we knew what we were looking for. And then we have what we call the first landmark and the second landmark of blood vessel, so that we're actually able to work out where the blood vessels were going and have this, what we call the automatic tracking procedure. So the Patent Office looked at that. There were some similarities with what had been done in the past and how people have been able to do it in the past. But we changed, we added some words, we explained to the Patent Office exactly how we had been doing it differently. And the nice thing about it was we'd already thought about some of these objections when we had originally filed the patent application. And so we were actually able to extract the information from the original filing description and put it into the patent application. Now, a method is great, but actually, if you think about what you are trying to do, if you, for example, are going to be a company that is selling this device, maybe you're selling X-ray machines, maybe you're selling a computer program that is actually doing this work, and you have this method, it's implemented, and you've developed this method, the people who are actually going to use it are going to be those people in the hospitals or in clinical surgeons. And those would be the people who would actually infringe a patent. But it's actually very, very difficult to sue a doctor for patent infringement. In many countries, it's excluded. In Europe, well, theoretically you can, but most people don't. It would be very bad publicity. Who are the people that we really want to think about who are going to be infringing the patent? Who are the people who want to take a license to our software? Well, at the end of the day, they are going to be the people who actually produce the apparatus who are doing it. So it could be a company like General Electric or Siemens who produce X-ray machines, or other companies that are doing it. It could be, for example, a specialist software provider. It could be, for example, maybe even a health insurance company that's doing something like this because they want to make certain that we get the right type of breast tissue to reconstruct the breast. So there's lots of people that you can do it. None of these people are actually going to be operating on the patients. That's going to be the hospital. That's going to be the specialist staff in the hospital. So in addition to our patent claim on the method for segmentation of blood vessels, the real thing that we really wanted to do, what we actually added to the patent application is a claim which is directed to an apparatus for the segmentation of blood vessel. And you can think about that if you want. I've got my X-ray machine here, and I bolt on an apparatus for actually processing these images, or a database for storing a plurality of images, a processor configured to analyze the plurality of images. And here's the crucial thing, with a software carrying out the method according to one of claims 1 to 7. So the claims 1 to 7 were the method. So what I've really got here is a brilliant device that is actually carrying out this method. And that's something that's going to be sold possibly by Siemens, General Electric, one of the other X-ray machine manufacturers. The other thing I wanted to think about when I was drafting this patent application was what happens if somebody just produces a computer program, puts it up onto the internet so you can download it. just like we download our Spotify tunes or our Apple tunes, or we download games to play on the internet. Yeah, there are app stores out there now which you can download programs for medical imaging. Siemens have a whole suite of application programs that you can actually put onto their various devices. Obviously, you have to pay for it. They're a bit more expensive than maybe the 10 euros we might pay to Apple for downloading something from the Apple Store or to Google from downloading from the Google Store. Yeah, we're talking sometimes the prices of several hundred euros, maybe even 1,000 euros to do something like this. But if I want to stop somebody who's working in a hospital from doing it, what I also want to do is to have a patent application directed to what we call a computer program product, stored on a non-tangible computer readable medium and comprising a plurality of instructions, which, when executed by the processor, actually does this method. Just think about this. I don't know how many people know the Siemens App Store, but just think about when you're downloading from Google Play or from the Apple Store. That's exactly what you're going to be downloading. So if Google or Apple had this program up on their store, they don't, and they probably will never will, you would be able to say, okay, Google and Apple, you are infringing our patents. It's in Europe, so anybody downloading our patents in Europe would be infringing this patent application. So what did we really learn from this example? We learned that if we've got a technical implementation, if we can describe in some detail about how the data is being processed, and we can explain to the patent office what the neural network we're using, how the data is being pursued, and we've got sufficient information in the patent application that we can explain to the patent office why that is new and inventive compared to the prior art, we are actually in a good position to actually get that patent granted. And then what we need to do is we need to think about who needs to license the patent. In our case, it could at least theoretically be Siemens General Electric. So we will have claims directed towards the apparatus for carrying out the inventive method, or it could be somebody like Google Play or an app store. So we have a claim directed to a computer program product. Once we've got that sorted out, we actually are in a really good position to have a good patent, which we can use as the basis for our business decision. So one of the things I'm often asked is, can we just summarize what we've actually learned? And I think the most important, and this doesn't just apply to artificial intelligence that we were talking about, if we really focus on the technical features when we're writing a patent application implemented by software, we are in a really good position to get a good patent. And there's a brilliant decision that was actually came out of the United States, where it was Philips Medical who had filed a patent. And people had attempted to challenge that patent on the ground that it was a software patent and was too wishy-washy. It didn't really explain what was going on. And the court in that case said Philips Medical had done a brilliant job of really emphasizing the technical features. Philips Medical had actually searched and described the technical contribution, what the inventive really did compared to our prior art, which we'd also done in the ESTEC patent application. Now, some people will also say diagnostic methods are not protectable in Europe. So one of the reasons why we actually wrote the patent as we did, we didn't want to say a method for identification of breast tissue, because the key was all about the segmentation, understanding blood vessels. That's why it was written not as a diagnostic method or as a surgical method, but just for analyzing the images to get the blood vessels. Slightly different in some other countries, but that's what we have to think about when we're doing something in digital health. Is it a pure diagnostic method, or has it got other advantages? However, even if you have a pure diagnostic method, you can actually get a patent on a device that implemented that diagnostic method. And the last question or last point that I wanted to make before we just come slowly to the end of this, some of you may have heard a lot of the discussion about whether an artificial intelligence machine could actually create an invention or not. And I think the answer is fairly clear at present in Europe. It's not possible to argue that a computer is an inventor. The computer is always going to be fed with data from that is originally selected, or the way to select it is created by a human. The artificial intelligence is always going to be programmed, at least initially, by a human who's going to define the subject. There's something called singularity, which the artificial intelligence enthusiasts like to tell us is going to happen soon, when computers are able to think for themselves. I don't think we've got that. And even the big example that you may have seen in various newspapers or in specialist magazines called Dabus, D-A-B-U-S. Basically, Dabus doesn't really create anything itself. There's other examples that Siemens have shown, which relates to a car component, where the computer has basically designed the car component itself, but using a large amount of data that's been input by a human and programmed by a human. Who is the inventor in that case? Well, I would argue that it's almost certainly the human, but I've got other people who to argue very differently. So just as a last point today, some people actually say, what is the best way to actually get a patent application granted? Now, one of the things in the way we actually did this with the Ineshtech, and I'm just taking this as an example, we've actually made a first filing in Europe in that case. We got the feedback from the patent office within a few months. We then did a second filing. In the particular case, we didn't actually go through the international phase, but it's probably the best way to do it. And then later we filed individually in different countries, depending on where the best way to do it was. But certainly this whole idea of updating the initial patent application, the patent application you saw a moment ago was actually the second one that was updated. This one, the international, it was the European filing in that case. Because one of the things we did have our first feedback from the patent office telling us what they initially thought of the patent, where they thought that there could be improvements. Well, they didn't tell us where they thought there could be improvements. They told us where they thought our patent application was not up to scratch. And there were some various things. There were some formal things there, but most importantly, they cited to us, they came back to us with these examples of the academic papers with similar things in it. And we were able to describe, or we were able to discuss these similarities with the inventors before we filed our initial patent application. So that was the way we did it. We went through. We've got, say, Daniel may tell you the fate of that patent application. It's no longer valid in Europe and some other countries, but that wasn't anything to do with the fact it was software based. That has a much more commercial aspect to it. And I'm not revealing any secrets. Daniel may be able to tell you why the decision was made. But we saw here that we actually are able to get it. Some people actually ask me what sort of the typical costs for filing digital health patents. They do tend to be a little bit more expensive than many other patent applications. One of the reasons for that is because they do tend to be a lot longer and a lot more difficult to write than if you're doing, for example, a pharmaceutical-based patent, where all you need to do is to describe the formula and the manufacturing method, or a simple mechanical device. What I've given here are sort of fairly typical sort of fees that you might expect to pay for producing or doing a patent application, particularly once you get into Asia, where you have to start filing the patent translations into the national languages. So that's basically the end of this short presentation, where I've tried to show you where we are, how to think about getting a software or an AI-based patent application. I've tried to show you the thought process, the drafting process that we went through in the collaboration with IneshTech, and I showed you how we prosecuted, how we were able to get this through the patent application, through the patent office, reasonably easily, reasonably effectively, by actually updating the patent as it goes on. So thanks you very much indeed, and I'll pass back to Miguel.
No, thank you, Robert. You always make it impressive when you speak about patent and laws. This seems boring stuff, but in the end, it's quite impressive when we go into the depths on these things. So we'll have a discussion Q&A in the end of the two presentations. So if you have any questions, feel free to Q&A. So we'll move directly now to Daniel. So Daniel Vasconcelos is the head of IneshTech TLO, so the Technology License Office. So as you can see from what Robert shared, he works with a lot of patents in the software area. Actually, IneshTech is for 4 years in a row one of the institutions in Portugal that has granted more patents. So Daniel himself has been working a lot on the ICT and medical device area, because one of the areas that's also IneshTech works. And beyond many other roles, he's also quite passionate about the topic of open source. So I dare someone to say that he's not developing software without using some kind of open source things. So it will be interesting also to see his insights on this topic. So Daniel, to you, if you can share the presentation.
Okay, thank you very much, Miguel and Patricia, for the kind invitation. It's a pleasure to me to speak about this topic. It is an additional pleasure to share with Robert the floor. Robert was one of the first experts that teach me about computer implemented inventions, and now we have working together for some years now, and he did a great job. So my job now is very easy. So, but I will address it in a different way. So I will not focus just on patents, okay, because Robert did it in a very well manner. I will talk about how we, as a technology transfer office, manage software and software in the digital health. So about me, so these are the topics for today. So to inform you and to clarify why intellectual property rights, so IPRs, are important for this kind of entrepreneurship. What is the perspective of the TTOs and how we do our job? Some of the case studies of IneshTech in a very briefly. I will not detail so much as Robert did. I will address that one, but just to have an overview and other examples that can inspire you, and finish my presentation with some recommendations and what you can or what you should avoid. So Miguel, thank you for the kind introduction. Is exactly that. So I'm the head of technology licensing office. So we have an active patent portfolio of 30, and IneshTech is an R&D institution in ICT and medtech. So much of our work is software. So it is a very familiar topic to us. And a part of that, I'm also invited professor for biodesign at Faculdade de Engenharia at Porto, and also I'm a European IP Help Desk ambassador for Portugal. So IP and healthcare are very, very interesting topics in the field of my work. So very briefly, all of us know that digital is here. Everybody speaks about digitalization, and the stock market show exactly that. If you compare the top companies and their value, market value, we'll find now that Alphabet, Google, Netflix, Facebook, blah, 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 are the first ones. But if we come back maybe 20, 30 years ago, the companies that were at the top 5 were the ones that are mostly based on physical assets, I would say tangible assets. So stock, facilities, factories, and so on. And this mindset and the way as the economy works nowadays, it changed completely. And this is the tendency, okay? So, and you work in an interaction between two very big markets, between the digital and between the health. And here you face an high risk that comes from the health, and that implies a very high level of regulation, as you know, FDA and so on. But on the other hand, there is an high value, so very big markets with a high level of rivalry. So, and all these markets are global. And these are the major factors, determinants why patents and IPR are key in these fields, okay? We talk about other fields, maybe IPRs are not so important, or to be clear, maybe other kinds of IPRs will be more important, like trademarks and other kind of IPRs, okay? Why patents are important, especially important here, because of the roadmap that all of you know, okay? The time to market that comes between the first idea, the first concept, until the product to be marketed, and the behavior of the competition when they start to develop alternative solutions is very long. So you should have protection that ensure you, I would say, 7 years or more. 3, it depends on the medical device, as you know, but 3 years is very short, it's very challenging. It depends a lot of manufacturers, the team, the cash, and so on. So patents are a trade-off between the opportunity to disclose your technology and to get the protection, because would you invest in such a risky business? So you know the numbers, the figures, so the success rate is very low. The risk and the investment required is very high. So patents fits very well to enable this kind of venture. Okay, and this is why IP is very important for business. The first concept is exclusivity. People from business loves exclusivity because that is what makes me unique, what defends myself from the competition. Okay, that's that one. So we can use an additional term that is a sustainable competitive advantage that I can get through IP, and that is very important to attract investment. Okay. So when you talk with venture capitals and even with other sources of funding, even at Portugal 2020 or EIT, so they maybe the first question or the second question is your technology protected, or can it be protected by IPRs? Okay, that is because investors want to feel it safe. So if there is IP, the risk of the investment decrease in a very high level, okay? On top of that, patents, trademarks, and other kind of IPRs works as enhancers of your reputation, okay? It is very often you can go into websites, find products and services, and then they will say patent protected technology, blah, 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 blah. So that also is important to you. And the fourth reason is because when you have IPRs and because there is a huge consensus worldwide, it makes very, very easy to do contracts, because you can just put one line with the number of the patent, with the number of the trademark, blah, 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 and it is easy to do a franchising, to find a partner in the other side of the world, and to expand your markets. Okay, so IP is not just to protect, is as an enabler of your business. Okay, and now going and returning again to the digitalization, there is no just one product. Nowadays, you have systems, ecosystems, where you develop hardware and software. As Robert said, the very good example of Siemens. Siemens have X-ray machine, CT scans, and then Siemens has an app store where you can expand the capabilities of your devices downloading software, okay? The Sinju, okay? I want to quantify the calcification in some vessels. I want to automatically detect some broken bone. and so on. So this is the kind of arena where we are now moving when we are developing solutions for medical technology. Okay, and that can goes in an additional layer. Okay, this slide is not from myself, it's from Strasbourg, from SAP, and you can see that we can go from the physical product that would be a machine and goes towards the digitalization, and there are several layers where you can offer your solutions and build a digital ecosystem that you need to know how to protect this fence, because if you prove that someone has willingness to pay, competitors will appear in a very, very fast pace. So patents are very important, but they are just one of the many tools that you can use. And as Robert pointed out very clearly, data now is very important, copyrights, trade secrets, and their value is growing. Okay, and things are changing and you need to be ready. Even for pharma, when you think about Pfizer and Novartis and Sanofi, we think as drug makers. But even though these companies are filing patents in medical technology and in software, and what these guys are filing, okay, this one is from Novartis, and they are filing a graphical user interface system. So this kind of how information is organized. How can I make the ophthalmic surgery be more efficient, avoid mistakes that are dangerous for people, for the patients? And why? Because Sanofi has a lot of drugs that this ophthalmic surgery applies during this surgery, and they want that the efficiency be very high. Okay, so if you speak with pharma companies, one of the major problems is not because they don't have the very powerful drugs available. Okay, for some diseases, yes, but for many others, the problem is the patients do not consume or use the drugs in a very right way. They forgot about to take medication. So there is a problem of compliance. Okay, and that is kind of things that software can help. This is another example, this one from Sanofi. So where you have a device, okay, but there is software in there that can help you at calculate the right dose for administrate insulin or any kind of drug. So software, pharma is all over the place. This one is a granted patent at US. And if you check, it was from 2020. So it is happening. Another approach is without patents, you can exploit your software. If you work in an R&D institution, if you have an academic software, you can do as this one, UMD Predictor from the Université Marseille. So what this app says here is, okay, this academic tool is free for non-commercial users. So other resources that want to use, we are happy to share. But if you are a laboratory, if you are a company that have a commercial purpose, okay, we are very happy to sell you a commercial license. And using this dual licensing strategy, you can get some extra money to you, okay, but and you can exploit your IPRs. And here it depends, okay. You can decide to have a software as a service, and we are talking that your software is a trade secret. Otherwise, we can say that maybe your software has also copyrights in there, and you are exploiting that way. Okay. So, and now, as Robert presented you in this breast cancer case, the data is king now, but not all data, high quality data, because training is just an AI just part of the game. You need very high quality input to be successful in the end. And Robert had this in the first slides, that databases are also protected by 2 intellectual property rights. Maybe this one is sui generis. It is not the content, okay? It is the effort. So You as a company, if you have a person that are collecting the data, are checking its quality, made it available, organize it and stored and so on, there is an effort and economic investment that should be respected. And this respect is achieved through this sui generis right, okay? We can talk about a copyright if your database is original in itself, but I will not address that kind of discussion because the time is very, very short now. Maybe one of the most important slides for today is this one. Your software, it is not just a source code. It is not just object code. There is a full process that comes from the problem, the need, and goes until the end, the very product with a brand name that you can file, okay? And here you can choose different intellectual property rights to protect the different layers. If you see here, patents are just for one, for the technical solutions. Patents are protects technical solutions for technical problems. So they are linked to the functionality, not with the other things, okay? If we are the source code, so coming back, so I have a solution, okay? And I can find many different ways of implement this solution. If you are developers, you know that. So the source code or the binary is not protected in the patent. So you will not find a single line of the program in the patent, okay? Just a fluxogram with a high-level idea, concept, but they are protected through the copyrights, okay? And all these together, so this kind of holistic IP strategy is very important so you can capture the value that you are creating to make it exclusive, but it is something that is very important to be said and clear. If you are a startup, if you are a small, medium-sized enterprise, what we will do if you find that someone is infringing your rights, okay? And it depends. You can find very nice people on the other side that did it accidentally, and maybe you find an opportunity to license your technology, to build a partnership and so on. But it's important to be said that many times, if you have a colossus from the other side, that he says, okay, suit me, go to the courts. I know that you have no financial resources. So what's up? Okay. And we need to be ready. Additionally, it is very difficult to detect infringement in digital. Okay. It is not kind of, I have this kind of pen, I can compare because the pens are sold every around the corner. No, it is very difficult to detect infringement. So be prepared and take it in account when you define IP strategy. Okay, but so in this field and for entrepreneurship, the major goal is to use the IPRs as key assets to raise investment, to raise capital. What we do as a TTO, we analyze and access all the R&D results from in ESCTech, from a university or what happened, and we try to create value through these intellectual property rights. Researchers are often very focused on thesis, paper, and conference that address the academic world, and we try to create value through three ways: spin-offs, direct contract research with some company, or selling or licensing our technology. We decide, and every single case is a different case, so there is no size fits all, okay? But our major goal is to have societal impact. So make our technologies be available in society, okay? And what we see in the last years that all of our results at least have a part of software. So software is around the place. And that is important because there is a blind spot here. Many times companies are not really aware of the free and open source licensing. They are there. We use them as tools, but they can be a double-edged sword, okay? Because the free open source, there are several licenses, okay, but all of them respect these 4 freedoms: the freedom to use without restrictions, okay. So I cannot say I cannot distinguish a commercial use from a non-commercial use. As soon as I distribute with a free and open source licensing, everybody can use, okay. They have the right to copy, to access the source code, and to modify it. And then depends on the license, they can close, they can do whatever they want. But remember that free is free from freedom, free speech, and not as in free beer. So it is no royalty free by default. Many times it is, okay, but it is not mandatory to be free of charge. Okay, there are several ones that you may know. Okay, I will just to have an overview. We know R, LibreOffice, Rails, and they are open source. And all of you, I'm pretty sure that you know and use open source. Please bear in mind that these are the major myths, though. So if you incorporate open source in your software, you will not able to commercialize it. That is wrong. You can do it, you can close it, but you have to check all the libraries and third parties libraries and components that you are using to check what you can do and you cannot. The second myth is that you cannot charge money for open source. Is not true. Okay, you can do it. If you incorporate open source in your software, you will be obliged to publish your source code. It depends. It is not necessarily true. And that open source has no copyright restrictions. It has nothing to do with copyright restrictions, okay? Open source is a licensing approach. It has nothing to do with ownership and so on, okay? Just an example from the medical field. So Aussierix. Aussierix is an image processing and visualization software, mainly for DICOM images. It starts by using open source licensing, so LGPL, and then after many people, many doctors start to use, they decided to return to the proprietary, okay? Because they expand, the software is evolving, and so from 2010 they are proprietary, and they have now a business model that they have a free product, the late one, and the Aussierix MD, that is a cleared medical device by FDA and also in Europe, that requires you a subscription for about, I would say, 70 euros a month. So this is how you can do a roadmap. So start using open source as an enabler and then build a business model afterwards. Okay, some case studies. This one is what AccurateVVV is the case that Robert showed you. So it was developed with the Fundação Champalimaud. It is not a medical device, it is a research tool, and there are some lessons learned. I will show you, I think, 5 or 6 cases with some lessons learned that I would like to share with you. So it is the first computer implemented invention to be granted to INESCTEC. In patents, priority date is critical. In that case, Robert didn't mention, but there was a problem at the first filing. Okay, and 1 week was enough to kill the opportunity afterwards. So in that week, there was an additional scientific paper that was published, and then examiners used this new paper to attack our patents. And that was very critical because at the US, we did a lot of effort, Robert did a lot of effort, and the US PTO didn't grant it, the patents. As all of you know, the US in medtech is the market, is the huge market. So the business opportunity was lost, okay? On top of that, there are other things that you should be aware. It's about the broadness of the patent claims, okay? And to look if they are aligned with an addressable market, and the size of this addressable market is enough to enable a business opportunity. These breast reconstruction surgeries are very important, but no investor was available to put some money in the company unless we show them that we can expand the application of the software for other customers, for other segments, for other surgeries, okay? So that's our very important lessons learned that I would really like to share with you. The second one is Ilove. Ilove is a startup in the Portuguese ecosystem. It has an AI patent that is for detection of a kind of biological target, these extracellular vesicles that are present in many, many diseases. Two lessons learned from this case. The early first filing was an enabler of entrepreneurship, or inventors decided to participate in the AccurateVVV wildcard because they had a first filing, so they can be free to disclose and to be confident. And this is the first filing that is also active. So patents as an enabler of entrepreneurship. And it enables also an additional challenge. It is synchronized with the publications that the PhD of the main inventor demands, okay? And so it is possible to publish, it is possible to do a lot of things because there are patents in the place. iAndio is a medical technology. It is a wearable device, okay, to help neurosurgeons and to implant a DBS stimulation implant. And there is a company, a spin-off from Inestech called InSignals Neurotech, that are doing all the way to the market. At the beginning, the concept of iAndio seems to be very simple. Okay, I know, okay, is trivial. Okay, it is not that trivial. So it is inventive in many countries. We have granted patents in China, US, Europe, Japan, South Korea, and Canada. Okay, so we have a very good level of protection. And during the product development, many other IPRs emerge, like a design, copyrights, trade secrets. So they appear along the way. Safe Cloud now moving for another place in cybersecurity. So this is digital information storage to wide security and privacy. There is a spin-off also from Inestech called AccurateVVV. These guys, they decided to go into the web summits and publish some papers on the invention, and then they call me, oh, Daniel, we are getting really excited, we decided to talk to everybody. Can we protect now using a patent? Because we have some investors that are talking about that. Okay, and that was a very critical moment, but we managed, okay? It is not perfect, but we managed. Because at the United States, there is something that is called a grace period, okay? Grace period is 1 year after the disclosure, so the publication in this case, the inventors have the right to file a patent, okay? And that patent was filed, the patent was granted, and it saved the business opportunity because investors are happy with the US and the level of protection and so on. So bear in mind that there are some ways of living with uncontrolled disclosure, but they are not perfect. In Europe, they are not available. There is a very big discussion in this moment again about the grace period in Europe, but that is not possible, okay? With Sense, this is an internal project for, we have 3 patent families, one for a wearable, 2 of them for software. One is BitID. BitID is a computer implemented invention where you can identify a person in a single heartbeat. So I put my finger, the device get my ECG signal in 1 or 2 heartbeats. The software knows that is Daniel, okay? And the second one is BitStress, where we are using for firefighters, policemen, army, where the people are being monitored and we can detect instantaneously and in real time that they are suffering from extreme stress and they must be removed from the scene. Okay, why? Because AI enables to do it in real time, and that is the inventive step. Because the other methods, they required a window between from 30 seconds, 60 seconds, and in this high performance, it is not compatible with the application. Okay, Deep Predator, so artificial intelligence to reduce energy consumption in wastewater treatment plants. Águas do Tejo Atlântico is being used, and it saves a lot of money. It reduces 20% of the energy consumption, and that is a lot. If you want to know, wastewater treatment plants, so ETAs, as we say in Portuguese, are one of the major energy customers in Portugal. So to just going to the end to my presentation, so some recommendations. So the first one, when you are developing your technology, do the freedom to operate. Look at the patents databases, look at the Google. There is a very good tool that calls Lens, so lens.org, where you can do the search for both patents and scientific papers to check that you are, from one side, you can protect your solution and you are not infringing third-party rights. Bear in mind that no size fits all, so there are many IPRs that can be combined in a very customized way. IPRs can act as an armor and a trade coin, so they are negative rights, so you can use them to defend from the others, to get exclusivity, got the money, but also to do some cross-licensing. Maybe you find a partner that's their own IP, so we can change. I use your IP, use mine, and we can grow together. Bear in mind also the software life cycle. Okay, maybe my piece of advice is to use patents or trade secrets to protect the core, something that will be being used in 3, 4, 5 years, and use copyrights and open source to protect or enable other parts of your software. You have to be very strategic here. Don't forget the fit with your business model, because that has an impact. If it is a freemium, it is a software as a service, and so on. Keep ownership and shared success. That is important because many times the company that is developing the software is not the company that has the data, and how we can do a partnership on that. Keep the ownership of the AI and the software to you, and share the revenue, share the reputation with the hospital or with the company that are providing you. But other kind of arrangements can be possible. But this is a rule of thumb. And learn to focus in what the technology can do and not on the way or how the technology works. So share the non-confidential information data and avoid to have problems with competitors and so on. So don't disclose too soon. The papers, conference, fairs, but also social networks, podcasts, and so on. Check with your managers on the IP, on the business strategy. Don't just rely on patent protections, because infringement protection is very difficult. Don't ignore open source compliance, because it has an impact on patentability. Some of these licenses like GPL3, Apache 2, and others have anti-patent clauses, so that you can have a patent, but you cannot use it. It can happen. And there are also other problems between compatibility between licenses and also compatibility with your business model. And don't wait for the final version to ask for customers' feedback, and test and fail as soon as possible. You can find more examples at a European Patent Office. This one from Cosmed, the Italian company, present to you how the IP facilitates cooperation. It enables premium prices. Early filing are very important, namely in medtech, because it gives you the time that you need to be compliant with the regulatory standards. I would like to end to disclose with you the European IP Help Desk. Okay, is a free of charge service and program from the European Commission that has training. It is a devoted website, publications, events, and I would highlight the helpline. So if you are a company, SME, or you are involved in a European project, you have questions on intellectual property, you please email helpline. It is free of charge, 3 business days, and you got a very good answer and first suggestions to your case. And thank you very much for your kind attention.
Thank you. It was quite a comprehensive complement what Robert brought and a view what is patenting software in practice. So now we'll open the floor to discussion. If there is any question from the audience, feel free to put it on the Q&A. But probably I'll start because there is often the other side of the coin of a patent, that is freedom to operate. And it could be interesting to discuss a little bit the challenges on securing proper freedom to operate in software, because things probably are not so trivial, or solutions become a little bit more complex when you gather open source, for instance. That was a good example of how could you probably have limitations on freedom to operate. So what is your views when you look into the other side of actually pushing a product forward and making sure that is no infringements with patents?
Okay, maybe I start. There are very good questions, very difficult to answer. When we move to the copyrights, the difference between 2 softwares based on copyrights is very subjective. There is no deterministic method that can show us that this software 1 is different from software 2. When you go to the court, what the judge will do, they will invite experts and try to see if the other software is original when compared with the first one. Okay, the term original, the concept of originality is the base of copyrights. So it is not enough to change a few lines in the software and do an alternative. Okay, I have to do it in a novel, original way. Okay, but it's very difficult to define what original is. So the best way is to avoid to go into this trap. And that is why patents can be a very interesting solution, because patents are broader and they are, I would say, without damaging, stronger IP, okay, than copyright. So when you go into the court, people will access claims, look at the concepts. So high-level concept. There are many ways of implement the concept, and all this implementation is protected, okay? But I will leave the floor to Robert, because that is the point where he is the expert.
And it's really interesting, because I think there's a lot of patents out there that are actually infringed. But in many cases, people don't worry about it at all. Now, why is that? Firstly, because if people are not having competitive businesses, then there's no point in taking patent infringement suits. So even if somebody is infringing your business or patent accidentally, sometimes you just don't even bother doing anything with it because it's not damaging your business. The second thing about it is within the ICT sector, so information and communication technologies, much more than in the healthcare sector, but in the ICT sector, most companies, all of the big companies, will license you their patent applications for a fee. They want some money, so you don't have to worry. So you look at IBM with 1,800 patent applications every year, and you think, how can I cope with that? Sorry, that's my wife. How can I work on that? But actually, it's very easy to go to IBM and say, I'd like to have a license to your patent. That's what one of the things I did within IBM. Where you need to be really careful is with competitors, people who are directly competing with you, particularly who are small or medium-sized companies. And that's where you need to focus any freedom to operate research. So that if you know that there is a Japanese, a US company doing very similar work with similar technologies, then you need to sort of look at the patents that have been filed by them to see if there's something which you might be infringing or might not be infringing. And then you can make a decision. If it's still a pending patent application, maybe you just wait and see if it's approved in a form that is going to affect you. And if that's the case, then you can file an opposition to the grant in Europe. Sometimes the patents are refused. There is never any worry about it at all. So I use a commercial database when I'm doing freedom to operate. I also get some feedback from the patent offices to see if we're infringing. But we suggest that it is only really worthwhile focusing on the real problems and not trying to identify potential problems that come along. And when we do, a lot of the work we do is with investors or preparing startups for investors. And there we'll show them these are the main competitors, because normally they're identified. This is the patent portfolio that the main inventors have. Oh, and 50% is still pending, so we ignore that. And of the other 50% of the patents, we have at least a good way of avoiding it. And every so often, you do find an issue. Every so often, you find a potential infringement of your product. And if we do that, then we have to decide, do we work around it or do we ask for a license? And quite frankly, the open ask for a license is often the best way to go forward. As I say, particularly with large companies, with real competitors, it can be more challenging. So, you know, Miguel, you've actually, you know, you've hit a real problem on the head. So how do you actually evaluate this? And I say the best way is to really just identify the real problems and don't worry too much about potential problems.
No, it's interesting. I love how you summarize in somewhere the FTO, freedom to operate topic in just an answer. So I'll challenge you probably with a question that I think is relevant also when we look to software. That is the speed as the products evolve. How you deal with the patents, because probably if you look to more traditional equipments, or probably you don't get your inventor coming to you and saying, oh, I did a completely new thing today. But when looking to software, probably what is now an algorithm for breast cancer detection, probably tomorrow is detecting liver cancer. And,
yes.
and it changed completely, probably the patent you had or the patent you submitted or your strategy. So how you deal with this, or in some way, if there is any way that should be, software should be looking in a different way to avoid these kind of issues that now, okay, we have a patent for something we are not actually doing because we changed the software in the past week.
Yes, and you know, that sort of thing happens, you know, new applications, and you think you've got an algorithm to detect cancer, but in fact, it turns out it's only for breast cancer and not for liver cancer. It means there are two things. It means really understanding what your patents actually protect. It means also making sure you have that open communication with your patent attorney, so that the patent attorney can also be proactive and suggest, you know, we didn't think about liver cancer when we wrote the patent on breast cancer. Sometimes it means rewriting the patent, filing it new because you've done something very different. In America, they have this concept of continuing patent applications. So you file one patent application, then you file a new patent application, then you file another new patent application. And there's some really quite complicated things like that. We don't have that in Europe. But the point about it is, Miguel, is you have to, you know, there is nothing that a patent attorney can do if you don't have that conversation with them to actually explain what you're trying to do. And if you don't, you know, as Daniel said, Daniel's highlighted a couple of cases where publications happened and then they filed patents. But if you do it, like I think it was Ilove you cited, where I think Johanna sort of really coordinated her thesis with the patent application, get it right, and you will actually be able to benefit from your academic career because you've published, and your patents because you've been able to get it in at the right time. So I don't know if Daniel's got any further comments.
Yes, it is also very challenging because there is a lot of pressure to publish, and it is okay. But now, as a TTO, after some years, now researchers trust in us. There is a relationship that and based on trust that was built, and we can now ask them to delay a few months because sometimes the papers are not ready, and is also a risk management. All this field is risk management. So ideally, I ask so they can submit their publication in the next day after we file the patent. There are some cases where they submit and then we file the patent 1 week, 2 weeks, and ask that reviewers and all the confidentiality in play is working. But we are not 100% sure.
Yeah.
So this is a game, okay? But this is a major challenging. When I'm going to conferences where talking about IP and there are only partners from the companies and big companies, their approach towards IP is very, very different. So be quiet and patents or trade secrets. Why? It's very simple. Why you can't do it? Because we are academics and we have to publish. So we have to find a trade-off between disclosure and protection as an enabler for future options towards exploitation, valorization, jobs creation, and spin-offs.
There's some really great examples, actually, if you know the field of some conferences where big companies on the day before the conference starts, actually file a large number of patents just to make certain that they've got the patents on file before the conference starts. So it's very much keeping on the ball. It's very much, if you think you've made a change to your software, then talk to the patent attorney or review the patent yourself. Is that really covered? Do I need to do an update? How can I do an update? There are means of doing updates. You don't always have to file a completely new application.
Probably a last question from my side, and here more probably to Daniel. Do you manage as a TLO probably today, because these patents, like getting this trust is something that I think for the last years, at least in Portugal, was not like 30 years ago, nobody was patenting anything. That you are involved on the early stages of the projects, because in the end, the sooner you have I think an IP strategy, as you said, the better. But is this something feasible? Is something that is you managed to do, of looking ahead? Okay, what may we develop ahead, and making sure that they know that they need to prepare that patent before publication, because there was discussed in the beginning that from that publication was already expected to come a possible patent, or it's more reactive work in the end?
No, okay, we are a proactive TTO, so we go talk with the teams and ask, what's up? We're doing follow-ups. Have you new stuff for us? And it works, okay, it works, but I should be very honest. In EschTech, as at this moment, running 250 projects, it is not feasible to scout all this. We are a team of 3-4, okay. So even though it is not possible, it is not feasible, and in Portugal, we lack a culture of IP, a culture of entrepreneurship. And so a very important part of our job is to raise awareness, to give them tools, so tables, flowcharts, where the researcher, when it comes to his mind or her mind, okay, maybe I have something here, it can follow the flowchart and avoid very big mistakes. And they have my phone number, so call Daniel, okay, and they call me. I think that's the process is being improved. we feel as in Hashtag that we have a responsibility at the ecosystem. So we want to be, we are connected with cutting edge associations like Robert is, ASTP. We attend and learn with them best practices. We are also connected with some TTOs abroad that are more experienced than us, and share it with our partners, share with our researchers, share with our colleagues at Portuguese TTOs, because we should grow together, and also with the companies. Every time that I do a new project with a company that is not give them everything by a very low cost price, they complain because they are not used it, and they are just thinking in Portugal as a market. But for healthcare, it doesn't work, because healthcare is a global market. So it is in the healthcare projects, as you see, that we are launching our spin-offs, we are doing best contracts, best contacts, and we are doing a better job, I think.
Okay, so I think we don't have further questions here. Patricia, do you want to say some final?
Yeah, so I think we have to close, but before that, I'd like to thank once again the speakers and also the attendees for someone with as very little insights over the topic as me. It has been a very informative and clear session with a lot of new concepts and ideas to keep in mind. So I've learned a lot, and I hope it has been as interesting for the attendees as it was for me. And just to highlight that Robert just shared a link on the chat about a webinar on AI and IP on November 10. So thank you, Robert. And just before we close this session, I invite you to follow the updates on the program of this series in our website. You may use the QR code that I imagine you're already seeing on the screen. And you can also follow the Health Cluster Portugal and the IT Health through social networks and know more about these and other activities. So that would be it from my side. And next week, we'll have a webinar dedicated to the topic of European health data space. So I hope to see you there, and have a nice week.